या कुन्देन्दुतुषारहार धवला या शुभ्रवस्त्रामृता या वीणावरदण्डमण्डितकरा या श्वेतपद्मासना या ब्रह्माच्युतं शङ्कर प्रभृतिभिः देवैः सदा वन्दिता सा मां पातु सरस्वती भगवती निःशेषजाड्यापहा
Quoted by Theodore Roosevelt, "No man is above the law, and no man is below it. Nor do we ask any man's permission when we ask him to obey it. Obedience to the law is demanded as a right, not asked as a favor." A very pleasant good afternoon to everyone, all the dignitaries as well as the participants. This is Aishi Sharma, and it's my pleasant duty to bid you all a genuine welcome on the behalf of Career Point University, Kota, at this insightful session on the topic Art of Judgment Writing. I would like to graciously welcome our eminent speaker, former District Session Judge Uday Chand Barupala sir, a well-known jurist and a social activist. He is the founder and national chairman of Uday Kaushal Foundation, Jaipur, Rajasthan. Thank you so much, sir, for accepting our invitation and gracing the event with your presence. Now, I would like to welcome and express my gratitude toward Dr. Neetu Naval ma'am, Dean of Law Department, Dr. Gurudat Kakkar sir, Pro Vice Chancellor of University, Ms. Mitlesh Malviya ma'am, Head of the Department, and all the faculty members for organizing this enlightening session on this crucial topic of judgment writing. Before we get started, I would like to take you through the purpose of the webinar. As we all know, judgment writing is one of the most crucial parts of judgeship, and mainly in judiciary exam for which most of the students are aspiring, judgment writing carries a good weightage. But there is no proper subject like this. So, while keeping this shortcoming in mind, this webinar is conducted. Now, before we go further, I want to review all the functionalities of the webinar. Please note, please mute your microphone to avoid background noises that may distract you from listening to the webinar. Throughout the session, someone is managing the chat functionalities. So ask your questions in the chat box, and the same will be answered at the end of the questionnaire round, but according to the time availability. Regarding e-certificate, the link for feedback form will be given to you at the end of the questionnaire. And for the certificate, please make sure that you will fill the feedback form and opt for the certificate. Now, we would like to move towards the session. I would like to call Dr. Neetu Naval ma'am, Dean of the Department Law. Welcome our guest. Over to you, ma'am. Ma'am, your mic is mute. Please unmute yourself. Ma'am, you are not audible.
Okay.
Yeah, ma'am. Now you're audible.
Okay, thank you. Good afternoon to all. It gives me immense pleasure to share, as Department Dean, that today's School of Legal Studies and Governance, Career Point University, organizing this legal workshop on very important and informative Topic: The Art of Judgment Writing. First of all, warm welcome to our today's eminent and dignified speaker, Mr. Uday Chand Barupal sir from Jaipur. Blissful welcome to respected Chancellor of Career Point University, Pramod sir, Pro Vice Chancellor Dr. Gurudat Kakkar sir, my colleagues Kunal Rohira, Mithilesh Malviya, Shailesh Sharma, Abhishek Meena, and dear participants. Today, it's a prideful moment for us that we are here with a high profile dignity, Mr. Uday Chand Barupal sir. It's our privilege to hear a well-known jurist and social worker. He served 17 years Munsif and Judicial Magistrate First Class, Additional Civil Judge of Additional Chief Judicial Magistrate, and Civil Judge and Civil Judicial Magistrate. He served more than 16 years in the cadre of district and session judges. He worked on the post of Registrar General Vigilance at the High Court Rajasthan, Registrar Rules at High Court Jaipur, Member Secretary Rajasthan State Legal Service Authority, Judge Industrial Tribunal and Labour Court, President District Consumer Dispute Redressal Firm, Member Rajasthan Subordinate Service Selection Board, Jaipur, Principal Private Secretary Honorable Lokayukt, Rajasthan. Respected Uday sir, conferred with many prestigious awards and appreciations at different platforms. He awarded for Best Judgment Writing by Governor of Rajasthan. His biography was published in Golden Book of Earth as the most inspiring people on earth. He is doing social work in every walk of life since very long time. He has created Uday Koshal Foundation to serve the society. Here is time limitation, otherwise many more to talk about this glorified dignity. At last, I would like to greeting with core of my heart to very inspirable and energetic personality, Uday sir. His biography conveyed the message that has to do something. That has to do something to get something in life. Life must be meaningful. We are very thankful and honored to Uday Chand Barupal sir to being with us. Thanks to all participants for your splendid response and registration for this online legal workshop. Thanks. Thank you so much to all.
Thank you so much, ma'am, for your words, for making us familiar with the great personality, Uday Chand Barupala sir. Now, while moving on the session, I would like to call Pro Vice Chancellor Sir Dr. Gurudat Kakkar sir to address the webinar with their inspiring words.
Thank you, Ayushi. So first of all, thank you very much to our honorable speaker, Barupal sir, who very kind-heartedly accept our invitation in order to share the great knowledge he have along with the students and budding professionals. As a student of law, I always feel that communication is in all manner is very much important in the profession of law. This is the only area, this is the only profession where all kind of communication mode remains important, whether it is verbal or written. As a practitioner, when we use the ease of communication, verbal communication at the same time while drafting, we use the written communication skills. But the thing which is moreover important is when you are acting as a judicial officer, and that time it becomes very important, very significant how you are putting your feeling at the same time facts and findings in words. I today I am remembering my father actually, uh, Mr. KB Kakkad, late Mr. KB Kakkad. He was RS officer, and he used to tell me that when you are writing a judgment, a decision is being written, then definitely the important thing is what you are feeling, what sort of evidences you have, that all matters. But it should be drafted, it should be put in words in such a manner so that it cannot be challenged in higher courts. If apart from whatsoever the facts and the rest of the related things you have gathered, you have heard, you have gone through, you are putting all those things in words in a right manner, in a very correct manner, in a very effective way, then the overall the judgment will become more effective. So as a student, we all are here to listen the authority in this particular field, and I won't take much time just because I am also very much keen to listen the uh, the the experience of Uday sir. So please allow me, and I'm welcoming again Uday sir and thanking him for sparing time. Thank you, sir. Thank you all.
Thank you so much, sir, for your encouraging and enlivening words. This energy will remain with us throughout the session. In the words of Arnaud, perfection consists not in doing extraordinary things, but in doing ordinary things extraordinary well. With this quote, I would like to call Honorable Sir Udaychand Bhavapal to help us to reach this perfection and make us extraordinary well in the art of judgment writing. Over to you, sir.
Honorable dynamic chairperson of Career Point University Kota, Sri Pramod Maheshwari, Vice Chancellor Honorable Sri Gurudat Ji Kakkar Sahib, Dr. Neetu Nuwal, Dean Department of Law of University, Mithilesh Malviya, Head of the Department of Law, faculty members Kunal Rohira and Abhishek Meena, distinguished guests, dear students, research scholars, lawyers, participants, and dignitaries connected with this program, this online. I am indeed very grateful to the university who invited me to deliver a lecture online on this legal workshop. The subject given to me is judgment writing is an art. Today is Friday. Friday is known as a pure day. As thoughts are the seeds of all actions, let me plant only good, pure seed to get the fruit will be the best. I hope that today's legal workshop will be considered on
I think there is some network issue. Please hold for a few minutes. We will connect with the speaker in just few minutes.
Hello, Ayushi.
Yes, ma'am.
Hello, Ayushi.
Yes, ma'am.
हाँ जब तक हाँ अगर सर का नेटवर्क में प्रॉब्लम हो रही है तो हम सर का जो जजमेंट है उसको हम शो कर सकते हैं उनकी स्लाइड्स
Yes, ma'am. Definitely.
ओके
Now we will show some of the judgment writing for which sir got the award. This is the judgment for which sir got the award. Please make a look through it. For this judgment, he was conferred the Justice Shri Vedpal Tyagi Memorial Award for the best judgment writing in Hindi in Rajasthan Higher Judiciary Service cadre for the year 1992 to 1993 by Rajasthan Hindi Vidhi Satarta Samiti. This is the whole judgment written by the sir. You can all see how eminent was his work. After the session, we will email you the judgment writing to all the participants so that they can be familiar with the judgment for which sir got the award. Then you can access the file through the email.
Hello.
Guys got connected again with us. Thank you, sir. Sir,
Sorry, there is a technical problem in this.
no problem, sir.
May I continue?
Yes, sir. Definitely.
In the first part, writing of judgment, we must know the concept of justice and concept of judgment. What is the concept of judgment and what is the concept of justice? ऐसा कहा है कि अधिकार खोकर बैठे रहना यह महादुष्कर्म है, न्यायार्थ अपने बंधु को भी दंड देना धर्म है। जयद्रथ पद में यह कहा गया था और इसकी थीम that theme was a justice, and justice always rendered on the rights of a citizen. Rights are the foundation of a civil society. Just a civil society cannot be imagined without the rights. Civil society has been dominated by rights since long past. Justice ignored from rights only. When a person demands a justice before any form, whatever it may be, the court or the administrative tribunal, indirectly he demands his rights. Means justice related to the rights. There is no era did a person renounce his rights. We can take example of Mahabharata. Mahabharata is a story of war fought between the Kaurava and Pandavas for their rights. Mahabharata war was the reason for Kaurav to deny the rights of Pandavas. Lord Krishna acted and tried to avoid the battle and to maintain the peace and harmony, but the Kauravas has denied the rights of the Pandavas. For that, Lord Krishna has went to the Hastinapur and advocated the rights of Pandavas. Pandavas' rights was explained and demanded by the Lord Krishna has been described by the Ramdhari Singh Dinkar in his poem Rasmirat. दो न्याय अगर तो आधा दो, इसमें भी यदि बाधा हो तो दे दो केवल 5 ग्राम, हम वही खुशी से खाएंगे, परिजन पर असी न उठाएंगे, दुर्योधन वह भी दे नहीं सका, उल्टे हरि को बांधन चला, जो था असाध्य साधने चला, जब नाश मनुष्य का छाता है, पहले विवेक मर जाता है. This is the concept of justice. Justice depends on the rights of the society. Concept of justice affiliated with the concept of judgment. Judgment is the judgment is provided for justice. Justice is the verdict or a judgment. Judgment or adjudication. There it time explained what is judgment. Today, the task of providing justice is doing by the judicial, administrative tribunals and revenue courts. The justice provided by the courts through their judgments. Without judgment, justice cannot be imparted. There is very importance of judgment in the administration of justice. It cannot be ignored providing justice. Now, I can say that judges are not a speaker. Judges will speak through their judgments. While in changing the society, judges will observe the theme of the society, because before courts, judges, every category of person appeared before the court, and even though they beggar to the rich person, every person in a time, in a day, when the 400 and 500 persons are across the court, then each category have across the court. There is a poor, there is a needy, there is a victim, there is a woman, there is a child, there is a child labor, there is a any category of the persons. So the court is visualizing the whole society by passing through the persons who appear before the court. What are the trends running in the society? Today, litigations are time and again they are changing their nature. One time there was no case of dowry and the kidnapping. Now you see the floods of cases in the courts of dowry and dowry provision, and you can see the matrimonial cases. I give an example. When I was a district judge in a district, there was I have to fix Saturday, Sunday for matrimonial cases. One day I convey my sense to the bar that this town is now changed in very much. They surprisingly shown resentment and tell me that how. मैंने कहा कि आपका समाज किस तरफ जा रहा है ये आपके लिटिगेशन से पता चलता है. समाज में विघटन क्यों हो रहा है? Why the today the sole families are developing, joint families are not. Every family member are not feeling the or responsibility of the joint venture. Now I come to the legal provisions of the judgment that generally, as per view of the man, a judgment to mean the ability of a judge to make considerable decision. Legally, section 2 of subsection 9 of Code of Civil Procedure defines the word judgment to mean a statement given by a judge on the grounds of decree or order. However, this exact definition is absent in the Code of Criminal Procedure 1973. To avoid this confusion in any finding of a judge at the end of proceedings of the suit or appeal or revision or the interlocutory proceedings, etc. Within the four corners of the law, it can be termed as a judgment. The finality of any civil or criminal proceeding is a judgment. The main purpose of the judgment is to communicate the parties and the stakeholders of decision of the court in regard to the litigation. A judgment acts as a precedent and therefore it should carry the message for posterity. It should be understandable by even those who lost the case. On what ground the party has lost his case, he has right to know it. He has to right to know. A judgment in the statement, a judgment is the statement given by a judge on the grounds of a decree or order. It is end product of the proceedings in the court. The writing of a judgment is one of the most important and time-consuming tasks performed by a judge. The making and the writing of a judgment is style in which it is written, varies from judge to judge and reflects the characteristics of a judge. Every judge of every rank has his own distinct style of writing judgment. A judgment is distinct for a formal order as it gives reasons for arriving at a conclusion. The explanation given by a judge for the pronouncement in the open court immediately after termination of the trial or at the some other subsequent date fixed by the court. The judgment is provided in section 354 in criminal law is to be written in the language of the court and shall contain the points for determination or the discussion. The section further provides that the judgment shall specifically the offense of which the section of IPC or other special law. In case of conviction, accused must be heard on the point of quantum of punishment. It is a demand of justice. किस अपराधी को कितनी सजा दी जाए इस बिंदु पे सुनना आवश्यक है। मैं एक उदाहरण के माध्यम से बताऊंगा कि क्वांटम ऑफ पनिशमेंट कैसे डिसाइड किया जाता है। आई एम गिविंग एन एग्जांपल 354 आईपीसी। एक अंधेरी गली के अंदर एक लड़की का दुपट्टा किसी ने खींच लिया तो उसको कोर्ट ने फाइन करके छोड़ दिया। एक लड़की की शादी हो रही थी, वरमाला पहनाने वाली थी, उस समय आकर के एक लड़का उसको छेड़ गया तो उसको पूरी सजा दी गई। दोनों की आप कल्पना कीजिए कि उस लड़की की क्या स्थिति थी जिसमें वर और वधू पक्ष के दोनों कितने लोग वहां थे, उसकी कितना असल्ट हुआ। एक गले के अंदर दुपट्टा खींचा, उसका कितना असर। तो एवरी सर्कमस्टेंसेस, एविडेंस, फैक्ट्स should be considered avoiding the quantum of punishment. The Code of Criminal Procedure and Civil Procedure have provided sufficient guidelines for writing judgments. These, however, not enhances exhaustive. There is wide discretion of a judge in the review petition, restoration, and other accepting common compromises orders. The CPC, Section 2, subsection 9 defines the judgment, and Section 2, subclause 4 defines the order. There is a difference between order and judgment. Judgment follows the decree that can be executed by execution provisions laid down in the Order 21 of the Code of Civil Procedure. Order 20 of the Code deals with the judgment and degree. It should be explained and it should be read it over. In criminal matters, Chapter 27th of the Code of Criminal Procedure provides for the judgment. Section 353 requires the judgment in every trial in order to totally or finally proceedings to be made. In civil matters, judgment as required of law goes may be broadly classified in two categories. First, long judgment and short judgment. Long judgment in them cases, the rights of a civil rights of a person who came to the court can be decided, like permanent injunction suit, specific performance, partition suit, and negotiable instrument suits, and the specific performance, etc., possession suits, and in a very preliminary issue and interlocutory order, there will be short order, not a judgment. According to the some talk on the BBC in 1979, the judgments in India or judgments in whole of the world can be divided in three categories. First category judgment fall in category of philosophers. In India, Justice V. Krishna Iyer's judgment were categorized as philosopher's judgment. Second, scientist's judgment. Justice P.N. Bhagwati and Justice D.A. Desai and Justice Kripal Singh all have scrutinized their judgments, and through their judgments they have conveyed the social engineering in the society. They have developed a new concept of legal aid, legal awareness, legal services, and so on. So the concept of judgment differs from judge to judge, but on facts and on legal provisions, verdict can be same. Judgment क्या है, निर्णय क्या है, न्याय की आत्मा कहते हैं निर्णय को. अच्छे जजमेंट के लिए क्या क्या क्वालिटी होनी चाहिए, क्या इंग्रेडिएंट्स होने चाहिए और क्या उसकी विशेषताएं होनी चाहिए. I will try to explain. In some words. A judge must, before preparing the judgment, he must go through the case file and he must consider all the aspects.
I think there's some network issue. We are trying to contact the speaker. He will join in few minutes. Please wait for him.
Ayushi, please continue that judgment.
Yes, ma'am. Now we will show you the case title, the name of the judgment. Here you can see topic on which the whole judgment was written. You can see the whole format through there.
Hello. Sorry for technical interruption.
Yes, sir. No problem,
Sorry
sir.
for
You-
technical interruption. May
No
I
problem.
continue?
Yes, sir, definitely.
I was explaining the ingredients of a good judgment.
Sir, your video, sorry, sir, your video is not visible, sir.
Yes, I continue.
Sir, your video is not visible.
Hello.
Yes, sir.
Yes.
Sir, you are audible, but your video is not visible. We are not able to see you, sir.
May I continue?
Yes, sir, you can continue. Yes, sir. Now you are available. Yes, sir, you can continue.
So, a good judgment. Index and introduction part relates to the preliminary introduction of the code, litigation, nature of case, presence of parties, presence of judges, and in which the first and foremost important thing is for adjudicating judgment is facts of the case. Clear facts should be narrated in judgment. Either it may be criminal or it may be civil. If the facts are not clear, then judgments will not be clear. Disputed facts of the parties must be clarified in the facts portion of a judgment. When I give an example that when entity file a suit for some recovery of money, defendant has filed his written statement. Thereafter, it is the duty of the court to frame a proper issue for determination of the dispute. इंट्रोडक्शन पार्ट के अंदर सबसे पहले मैं आपको एक चीज बताऊं कि मैं एक अनुभव बताता हूं कि मैं व्हेन आई वाज पोस्टेड इन जयपुर वन बेल एप्लीकेशन केम टू मी एज ए अपीलेट कोर्ट 439 लोअर कोर्ट ने 4 लाइन का ऑर्डर लिखा कि अभियोजक उपस्थित, अभियुक्त उपस्थित, अभियुक्त के अधिवक्ता उपस्थित और अभियुक्त के जमानत पेश प्रार्थना पत्र पर सुना और अभियुक्त का प्रार्थना पत्र खारिज किया जाता है। अब इस ऑर्डर से we are not able to identify the accused for which court has rejected the bail application. Means introduction part of the case is very important to identify the case, name of the accused, name of the parties, which nature of case is mentioned there, under what section each case is dealing with, and parties himself present in the court should be mentioned in the judgment. I was regarding the issues must be framed by the court. Issues law, legal issues. Then the judgment, outcome of the judgment will be better. Now I come to the point and the foundation of the judgment or the judge or the court or the legal system is based is evidence. Is evidence. Evidence must be recorded by the court. Now I want to explain the evidence in the judgment. A judge should appreciate the evidence on so many criteria. Evidence on facts, evidence may be oral, evidence may be documentary, medical jurist, blood report, required articles, weapons, clothes, handwriting experts, thumb impression experts, legal experts, and ballistic experts, chemical experts, and circumstantial evidences. How a judge can judge a witness that he is a reliable witness, and on his statement, a accused can be convicted or a suit can be decreed. There are so many criteria to evaluate appreciation of a witness is whether it is an independent witness, whether it is a relative state. कहते हैं ये इसका भाई है, ये भतीजा, सब ये तो भाई दूसरा देगा, किधर से आया देख लिया. इनिमिकल स्टूडेंट एक पारिवारिक वैमनस्यता रखने, इंटरेस्टेड इसकी एविडेंस का इवोल्यूशन कैसे किया जाए और एक्सपर्ट की एविडेंस कैसे कंसिडर की जाए, इन्वेस्टिगेशन जो करता है की जाए, और कोर्ट इस पे आपको must be appreciated in whole facts of the case, circumstances of the case, previous conduct of the case, previous conduct of the witness, subsequent conduct of the witness, subsequent facts and circumstances prevail in the case. On these grounds, the a statement of a witness can, or witnesses relative or interested or inimical witnesses, then how the court will decide the case. This is a fundamental principle that relative, interested, chance and inimical witness can be relied upon, but in totality the circumstances should support the contention of the witnesses relied upon, and then the court and pronounce the judgment and reach a particular conclusion. आपको ऐसा कहते हैं कि man can lie but circumstances cannot lie. I have decided so many cases based on the circumstantial evidence. But I want to share my experience in two cases. One case was a gang rape case. And in that case, 6 accused and her also involved. The trial is completed in the court. To reach a correct, I have evaluated all the witnesses, circumstances, anything. But at a time, this fact strike my mind that I should inspect the occurrence. Right to inspect the place at the place where the incident took place, but I don't that was in my mind. And one day after lunch, I called my driver and I called my personal assistant that we should go for that court for inspection. And that incident's place was in between the two distances. Then I traveled at least 45 kilometers. Region at that point of place, I instructed the driver that stop the vehicle, and I come out from the vehicle and मैं इधर मैंने उस देखा कि प्लेस विजिबल है या नहीं है, या ऐसा इस जगह 6-7 व्यक्ति, क्या इस जगह कोई गैंग रेप खुले आसमान, सारी कंडीशंस आई हैव विजुअलाइज्ड एंड in night I come back, and after 4-5 days I pronounced that judgment. I by inspection of the sport, I reached on that conclusion that incident is correct, and that is verified by the record, which circumstances must be in chain. We can say that गले की कड़ी टूट जाएगी तो गले से नीचे गिर जाएगी. में एक भी कड़ी अगर लिंक नहीं होती है तो अभियुक्त को दंडित नहीं किया जा सकता. कहते हैं कि 100 अपराधी बच जाए लेकिन एक दोषी, एक निर्दोष को सजा नहीं होनी चाहिए. सर्कमस्टेंशियल एविडेंसेस में सबसे ज्यादा ध्यान दिया जाता है और सबसे ज्यादा ये देखा जाए कि चेन ऑफ एविडेंस, लिंक ऑफ एविडेंस मस्ट बी दैट.
So, I think there is some network issue. You are not audible, sir. I think we should wait for a minute. Sir will definitely be trying to connect. We are really sorry for the network interruption. Till the time sir will connect us, let us see the judgment he has written. Let's continue with the judgment. As we are already seeing the name above, now we will see the content of the judgment. As we had already seen the format, at the upper side, the name of the court is mentioned. Below that, the case number and all is mentioned. After that, we can see that the name of the parties are mentioned as well as the sections of IPC, Indian Penal Code, are also mentioned. Here we can see that who are present, the name of those persons is also mentioned. After that, we can mention the date and then we can start the content of the judgment. We will elaborate all the details regarding the parties. As you can see, the address, the dates, and all the details are mentioned here along with the sections. The whole situation, the whole facts, how and when the thing happened is mentioned here. How the procedure has gone along with it.
आवाज आ रही है मेरी?
Yes.
Yes, sir.
हाँ.
You are audible.
Again, sorry for interruption. It is a technical interruption.
Yes, sir. No problem.
So, court should decide every point for determination which have been framed by a judge during the trial. And judgment should be given on every issues in relation to the civil code, civil matter. Every issue and every charge should be decided by the court on the basis or on the evidence laid by the parties, and court should appreciate in all circumstances of the evidence. In a good judgment, always avoid harsh remarks. Parliamentary language नहीं होनी चाहिए उसमें. Judge should keep in mind that parliamentary language should be used in the judgment. I want to tell you one thing, my dear students, that what is the language. We are talking of the evidence and each and everything, but what should be the language of our judgment in our constitution? Language of the courts is defined. In Supreme Court, there will be English language. High courts will be an English language. High courts are using their local languages. And in subordinate courts, regional languages. In Rajasthan, is Hindi. Other states, Kannada, Tamil, and Maharashtra and Punjab states have all that writings. Now, the section 354 Code of Criminal Procedure laid down the what will be the language of the judgment. And in every high court or in the subordinate courts, they are governed by the concerned high courts. There is a general rules, civil और general rules. Civil courts run करेगी, उनके नियम अलग हैं. Criminal रन करेगी, उनके नियम अलग है. उसमें जजमेंट की लैंग्वेज के बारे में भी बताया गया है. लैंग्वेज बहुत सिंपल होनी चाहिए. द चीफ गाइडलाइंस फॉर यूजिंग प्लेन लैंग्वेज इन द जजमेंट इज achieve a reasonable and average sentence. Simple sentence, छोटे sentence. Prefer short words or long words. Avoid double or triple negative. For example, I give an example. The document need not be checked unless it is desired by the parties. In courts, we are using the word the documents may be checked if it is desired by the parties. In judgment, always must use the एक्टिव वॉइस, नॉट पैसिव वॉइस। जैसे एक सेंटेंस का एग्जांपल है कि ही वाज एक्विटेड बाय द कोर्ट, न्यायालय द्वारा वो दोष मुक्त किया गया। मीनिंग द कोर्ट एक्विटेड ही, कोर्ट एक्विटेड है। लैंग्वेज must be very plain and simple language. Keep related words together. Break heads, subheads and breaks. ये नहीं है कि एक पेरा उठा स्टार्टिंग वर्ड से लास्ट तक एक ही पेरा लिख दिया। We are not knowing where is the head and where is the subhead in that place. So every point must be in paragraph, and every head and subhead will be divided according to the facts, evidence. Suppose oral evidence is one paragraph, expert evidence in second paragraph, medical evidence in third paragraph, circumstantial evidence in fourth, and the conclusion of the court is in the fifth paragraph. If we are amalgamating all these paragraphs, we will confuse ourselves. So avoiding the sentences, punctuation should be keep in mind. I share an example and experience that when I was a district judge and deciding an 125 CRPC's maintenance case appeal, I have gone through 4 or 5 lines of the lower court's judgment. Then I closed it. And then I have gone through the pleadings of the parties and evidence, and I have decided the appeal within 4 and 5 pages. Then when I returned to my chamber, and my personal assistant asked me, सर आपने लोअर कोर्ट का जजमेंट तो पढ़ा ही नहीं, आपने तो ऐसे ही लिखा दिया। तो मैंने उसे कहा भाई लोअर कोर्ट की जजमेंट में पढ़ने लायक कुछ है ही नहीं। कि कैसे? मैंने कहा जो पैराग्राफ ऊपर से शुरू हुआ दूसरे पेज तक कहीं पुलिस स्टॉप, कोमा, पंक्चुएशन कहीं नहीं है इस सेंटेंस से, क्या आप अर्थ निकालेंगे, क्या समझेंगे? तो सेंटेंस, पैराग्राफ एंड राइटिंग मस्ट बी स्पेसिफिक, क्लियरिफाई। अपने लिए नहीं है वो, हम दूसरे के लिए लिख रहे हैं, पक्षकार के लिए लिख रहे हैं। पक्षकार को समझ में आनी चाहिए, पब्लिक को समझ में आनी चाहिए कि कोर्ट ने क्या जजमेंट दिया। तो 200 वर्ड्स तक कहीं पुलिस स्टॉप, कोमा नहीं। वन सेंटेंस इज अबाउट 200 वर्ड्स। कैन वी अप्रिशिएट इट? नो। Then I replied that therefore I have not read this judgment. That I have decided this case on the facts, pleading of both the parties, both the evidence I have considered, and my judgment is only in 5 to 6 pages, and that lower court's judgment was in 45 pages. But you cannot understand 45 pages में एक लाइन का अर्थ नहीं समझते कि उस न्यायालय ने क्या फैसला दिया। तो गुड जजमेंट के लिए बहुत अच्छा सारांश में ब्रीविटी एंड हेड, सब हेड, पैराग्राफ एंड कैटेगरी ऑफ द एविडेंस एंड should be mentioned in the judgment. The foundation, most important thing of a judgment is reasoning and findings. मोस्ट इम्पोर्टेंट पार्ट ऑफ दिस जजमेंट है कि जजमेंट किस रीजन के आधार पे दिया है। मेरा दावा खारिज किया तो क्यों किया है, और सजा दी है तो क्यों दी है। मतलब एवरी जजमेंट, एवरी ऑर्डर शुड बी ए रीजन्ड ऑर्डर एंड रीजन्ड जजमेंट। आई थिंक टाइम इज वेरी शॉर्ट। आई कंक्लूड। मैं conclusion, judgment is required to tell the parties of the decision on facts brought before him with application or application of sound principles of law, his decision and what the parties are supposed to do and necessary consequent to the judgment or appeal against it. जो भी निर्णय न्यायालय करेगा, पक्षकार को समझाएगा कि ये जजमेंट है, आप उसमें अपील कर सकते हैं, रिवीजन कर सकते हैं, एंड all consequences of judgment must be explained to the parties. Parties should be understood. जजमेंट ऐसा लिखा जाए जो पक्षकार समझ सके कि मेरे लिए न्यायालय ने क्या लिखा है। मैं एक छोटा सा एक उदाहरण और दूंगा कि when I was posted outside Jaipur and once I came in the High Court, I was sitting in the additional registrar's chamber and two persons came there and asked the additional registrar that उन्होंने कहा साहब हमारे इस केस में क्या फैसला हुआ बताएं। I also gone through that judgment. He also go through the judgment for 3-4 times, but we both not understandable what we will. हमने उसको इतना ही कहा भाई तू जीत गया, अब घर जाओ आराम से। तो जजमेंट वो होना चाहिए जिससे जो पार्टीज है उनको तो पता लगे ही लगे, लेकिन सोसाइटी के अंदर उसका एक मैसेज जाना चाहिए। सोसाइटी की कल्चर, सोसाइटी की थीम, सोसाइटी का सभ्यता, संस्कार एंड लीगल फ्रेमवर्क के अंदर किस तरह से जजमेंट में इवॉल्व किया जाता है। सोशल फिलोसॉफी, साइकोलॉजी एंड क्रिमिनल माइंड क्यों होता है, क्रिमिनल माइंड को सुधारने के लिए क्या किया जाए, ये सब चीजें जजमेंट के अंदर आनी चाहिए। जजमेंट, अब स्टूडेंट्स हैं बहुत सारे, कुछ लोग आरजेएस में जाना पसंद करेंगे, कुछ वकील जाना पसंद करते हैं, कुछ सरकारी वकील बनेंगे, कुछ कॉरपोरेट बॉडीज में जाएंगे, कॉरपोरेट डिफेंस में, कुछ एडमिनिस्ट्रेशन में जाएंगे, कुछ अपना प्राइवेट व्यवसाय करेंगे। लेकिन इन सब के लिए भी कानून के अंदर ये जजमेंट क्या है ये समझना अति आवश्यक है मेरे हिसाब से। एवरी एडमिनिस्ट्रेटर, every institution head, apart from the courts, they always are passing the order to write the rights of a party. Suppose a university is deciding a student's application, that स्टूडेंट का राइट डिसाइड हो रहा है, वो भी जजमेंट है। उसके अधिकारों पर विपरीत प्रभाव पड़ रहा है, जबकि कानून ऐसा नहीं कहता। नगरपालिका ऐसा करती है, यूआईटी ऐसा करती है, यानी रेवेन्यू पटवारी रिपोर्ट करता है, उससे किसी का अधिकार विपरीत रूप से प्रभावित होता है। किसी गली मोहल्ले में चबूतरी तोड़ी जाती है तो उसका सिविल राइट के ऊपर इफेक्ट पड़ता है। तो एवरी ऑर्डर, every narration of a administrator is a judgment. In eye of law, judicial judgment is a separate thing, but this judgment, every administrative order must be written very cautiously, considering the totality में all factors should be considered, then it can be we called the judgment, and we are imparting the justice to the society. In the end, every law student is expected to go through the principles of art of writing judgments for future prospects. Advocate also considers this fact. If he is not well prepared for argument, reasoning, and facts verified, then he will lose the case. I say that every person who is related to the legal field must know the legal implications in his duties. मैं ज़्यादा टाइम हो रहा है इसलिए अपनी बात को समाप्त करूँगा। निर्णय लेखन, निर्णय की अवधारणा, न्याय की अवधारणा, अच्छा निर्णय कैसे लिखा जाएगा, अच्छे निर्णय में क्या चीज़ क्या होगा, क्या क्या एलिमेंट्स होंगे, भाषा कैसी होगी, एक्सपीरियंस कैसे लिखे जाएंगे, साक्ष्य का विश्लेषण कैसे किया जाएगा, मैंने बताने का प्रयास किया है। मैं अंत में यही कहूँगा, एक चीज, एक छोटा सा उदाहरण दूंगा मैं, एक छोटी सी कहानी के माध्यम से बताना चाहूंगा कि अच्छे जजमेंट में क्या गुण होने चाहिए। राजा भोज का नाम सभी ने सुना होगा। राजा भोज एक बड़ा संगीत प्रेमी था और संगीत सभा का आयोजन किया उसने। सब संगीत के सभी साज बाज जितने भी हारमोनियम तबले सब होते हैं, मंजीरे सब किए गए और दूर दूर से लोग उस संगीत सभा को सुनने आए। तो एक व्यक्ति आकर के देख, वो 10-12 कोस से पैदल आया, पैदल आकर के गेट के पास खड़ा होकर के देख करके वो अपना मुंह बिगाड़ करके वहां से रवाना हो गया। तो द्वारपाल ने जाकर के ये कहा कि साहब वो ऐसे मुंह करके गया, आपकी संगीत सभा उसको पसंद नहीं आई। तो उसको वापस बुलाया गया, उसको पूछा भाई क्या बात थी। तो उसका जो आंसर था वही आंसर था कि साहब मंजीरे वाले जितने लोग हैं इनमें से एक व्यक्ति के अंगूठा नहीं है जो मंजीर बजा रहा। चेक किया गया, वास्तव में एक मंजीरे वाले के अंगूठा नहीं था। तो क्या मधुर संगीत कब बनेगा? जब सारे इक्विपमेंट्स उसके अंदर एक लय और ध्वनि में आएंगे। तो मैं इस संगीत सभा को एक निर्णय के प्रतीक के रूप में अगर अपन देखें तो इसके अंदर फैक्ट्स, इंट्रोडक्शन, एविडेंस, एप्रिसिएशन, लीगल एप्लीकेशन, लैंग्वेज, साइटेशंस, सब चीजें अगर एक अच्छी तरह से आएगी, जिस तरह से एक संगीत मधुर ध्वनि निकलती है उसी हिसाब से सारी चीजों को अगर इसके अंदर समाहित किया जाए और एक अच्छी भाषा और परिष्कृत रूप और कानून के अंदर समाज की सारी परिस्थितियों को कंसीडर करते हुए अगर लिखा जाए तो वो जजमेंट अच्छा होगा और वो समाज के अंदर लाभदायी होगा और जितने भी इस फील्ड के अंदर लोग आएंगे उनके लिए प्रेरणादायक होगा। मैं अपनी बात इसके साथ समाप्त करते हुए ये कहूँगा, रॉबर्ट फ्रॉस्ट ने कहा था कि वर्ड्स आर लवली, डार्क एंड डीप, बट आई हैव प्रोमिस्ड टू कीप, एंड माइल्स टू गो बिफोर आई स्लीप, माइल्स टू गो बिफोर आई स्लीप। हमें प्रतिदिन कुछ न कुछ ज्ञान प्राप्त होता है, हमें सोने से पहले मीलों चलना है। मैं एक चीज इसके संबंध में ये कहूँ, भारत के प्रथम प्रधानमंत्री जवाहरलाल नेहरू जी के टेबल के ऊपर ये 4 लाइन हमेशा लिखी हुई रहती थी कि बिफोर आई स्लीप, माइल्स टू गो। जय हिंद, जय भारत। धन्यवाद मेरे को बुलाने के लिए।
Thank you so much, sir, for your intuitive words. We really enjoyed and entertained the session. This is how you explain us all the experiences you have managed and how you managed to do this and to achieve this. Thank you so much, sir, for this. Sir, there are few certain questions asked by the students. Can we go for the query session?
क्वेश्चन पूछेंगे, जवाब देंगे अभी।
Sir, can we go for the query session?
Ask any question?
Yes, sir. So let's move forward to the query session. There are certain questions that are asked by the students. First question from Shweta. She is live from YouTube. Can a judgment after passed by the court be changed if it is announcing of harm to the public at large?
Please repeat it.
Yes, sir. Can a judgment be changed after passing from the court if the judgment is harming the public at large?
No. If any judgment pronounced in open court, it cannot be changed at all. If anybody or it is not in public interest, then anybody can appeal before the higher court, appellate court, and he can exercise his legal remedy, but the court cannot change his judgment once the judgment is pronounced.
Okay, thank you, sir. I hope Shweta has got her answer. Now, the next question is from Abhishek, that What are the interim orders in the CRPC that
What
cannot
is
be
the
interim
what is the
orders? Interim
interim
orders.
order?
Yes, sir. In the CRPC that cannot be revised.
CRPC,
Yes.
interim order. So what is the question?
Sir, he wants to know that what are those interim orders in the CRPC?
Interim
Like
order.
how one can identify the interim orders.
Any order disposes the matter in toto, it is a final order. And kept pending final order during that. Just I give you an example. There's one person approached to the court for a anticipatory bail. He is apprehending that today I will arrest or tomorrow I will arrest. The process is long. Then as and when he filed the bail application before the court, court will call the investigation diary and the investigation officer and other material. On that juncture, if the court deemed fit, then court can pass the interim order till the application is finally hearing. He will not be arrested. This will be called the interim order.
Okay, thank you, sir. I hope Abhishek has got his answer. Next question. What are the special conditions should be required in writing a judgment if it is related to constitutional law?
Constitutional. There is no, now I explain here to that the constitutional matter is always decided by the High Court and Supreme Court. High Court jurisdiction can be invoked under Article 226 of the Constitution and Article 32 for the Supreme Court of India. Supreme Court India, Supreme Court and High Court, they have evolved their own style of judgment. When the constitutional matter decided by the Honorable High Court and Honorable Supreme, what point on what provision they have invoked, what thing, what issue has been raised before the court, that issue will be decided only. ट्रायल कोर्ट के जजमेंट के नियम वहां लागू नहीं होते. वहां हाई कोर्ट्स एंड सुप्रीम कोर्ट्स आर फ्री एंड दे हैव jurisdiction to decide the matters under the Constitution of India.
Thank you so much, sir, for taking our session and for answering the questions. As the time is limited, we need to end the webinar. So limited questions are asked, but we will try to answer you all. Now, I would like to call Ms. Mitesh Malviya ma'am, Head of the Law Department, to present a vote of thanks to our chief guest. Ma'am,
Thank
over
you,
to you.
Aishi. And a very big thanks to Honorable Sir Udaychan Barupal for providing a deep knowledge and insight for all students and participants who have joined this workshop today. This workshop will help the law professional in their future and career growth. Sir has excellently presented the judgment writing method from criminal and civil law, and the topic covered today in this workshop will also help the aspirant for judicial services. Sir, according to Sir, very important tips give us to that, like this evidence, investigation, difference between judgment, order, decree, and many others, evidence, circumstantial evidence, eyewitnesses, investigation, other area. This topic was covered, every area in this criminal and civil law. And Justice Oliver told us one line, I say this: the life of the law has not been logic, it has been experience. This line fulfills purpose of this our workshop. A judge renders justice through his decision. The decision making culminating in the judgment is the heart and soul of the judicial process. Good judgment enhance the prestige of the judiciary. Bad judgment obviously have the opposite effect. There is need for the judges to make a constant and continuous effort to render good judgment. According to Sir, worthwhile to keep following basic rules in mind while writing a judgment. Reasoning should be intelligible and logical. A judge cannot use his personal knowledge of fact in a judgment. Finding a fact should be based upon legal testimony. In civil matters, the judgment should not travel beyond the pleading or issues. Introduction section, setting out the fact, the law and the issues, applying the law, that fact, any other issues. Thank you very much, sir, for giving such information and guidance in our judgment writing. We acknowledge Honorable Sir Udaychand Parwal sir with a token of appreciation in the form of virtual certificate. Please kindly accept with our best regards. Please accept, sir. I would
Thank
also
you.
like to
Thank you very
thank you very much, sir. I would like also thank to our Pro Vice Chancellor, sir, Dr. Professor Gurudat Kakkar, sir, for gracing this session by valuable words and present. I would also like to thank on behalf of School of Legal Studies and Governance at Career Point University, Kota. I would like to say thanks to all attendees present in this workshop, and we hope to see you all again for such informative session. Thank you so much. Thanks.
Thank you so much, sir. Thank you so much, sir, and all the participants for joining us. A feedback form is provided to you all in the chat session. I would like you all to fill that feedback form for the certificate. Thank you so much, sir, for giving us your precious time.
Thank you. Thank you very much.
Now we would like to end the session.
Thanks a lot, sir. Thank you, sir.
Thank you.
Thank you.
Thank you, ma'am, and all
Thank
the
you.
dignitaries.